Ready, start. Incidental to that question, the court should also find out whether the plaintiff is recorded to be the owner or holder or occupant of the property in the revenue records or the municipal records, for more than 30 years, and what is the nature of possession claimed by the plaintiff, if he is in possession dash authorized or unauthorized permissive casual and occasional furtive and clandestine open continuous and hostile deemed or employed within bracket following a title bracket close full stop. The suit was filed in 1996, by which time the government was admittedly in possession of the subject land. Full stop. The petitioners slash plaintiffs inter alia prayed for recovery of possession. Full stop. Section 110 of the Indian Evidence Act states that, when the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. Full stop. Section 110 of the Evidence Act is material in this respect, and the High Court relied on the same, which stipulates that when the question is whether any person is owner of anything of which he is shown to be in possession, the onus of proving that he is not the owner, is on the person who affirms that he is not the owner. Full stop. In other words, it follows from the well-settled principle of law that normally, unless contrary is established, title always follows possession. Full stop. It is the clear and unequivocal stand of the respondent slash state that the land was resumed wide proceedings dated 3 to 1989. Full stop. However, the suit was filed only in the year 1996, without any proper cause of action, vague and artfully drafted amendments to conceal the delay, and thus the suit was not maintainable. Full stop. Having heard the learned counsel appearing for the parties and having gone through the materials available on record, the only question that falls for our consideration is whether the High Court committed any error in passing the impugned judgment and order. Full stop. Upon a comparison between a land patta holder and a land allottee, it can be seen that a land patta holder is a person who has been granted a patta within bracket a legal document bracket close that confers rights over a specific piece of land, typically indicating ownership or entitlement to use the land. Full stop. On the other hand, a land allottee is a person to whom land has been allotted by the government or relevant authority, often under specific conditions and for designated purposes. Full stop. There exist several key differences between a land patta holder and a land allottee. Full stop. With respect to the nature of rights, it can be seen that a land patta holder possesses rights that are often permanent, heritable, and transferable, as established under various land revenue regulations. Full stop. For instance, the Assam Land and Revenue Regulation, 1886, states that a patta holder has a permanent, heritable and transferable right of use and occupancy in their land. Full stop. However, a land allottee, may not have the same level of rights. Full stop.